Good afternoon, everybody. Thank you for coming here today. We were a little bit late in kicking off because we're hoping a few more stragglers might come in, but I think we're pretty much it at this stage. So for those who don't know me, my name is Noel Devons. I'm the chairman of Foil Ireland, and we're delighted to have you all here today to deal with this very exciting 2 speakers and 2 topics. So hopefully everybody will be very interested in what they have to say. So this is the first in-person event for Foil in 2025, and it's hard to believe we're already at the end of May and hitting into June, but such is life. We decided we got a bit bored with Westbury, so we thought we'd come down here and get ourselves a lovely view of the Liffey, but unfortunately with the sunshine and the videoing that hasn't happened. So maybe you can peek out there and get to see a little bit of it, but at least it's not lashing rain. So we decided to take on board the comments that we've received from our members, and particularly in relation to the last live in-person event in November, where our members asked for specific topics. And we started that in early 2025, and we're continuing that today. And we would ask that our members fill in the feedback forms later on today or email us just to give us suggestions for the next topics, because we can come up with our own versions of what we want to do. But the important thing is the people here actually give us suggestions and we will deal with those. So just some housekeeping first. Can we all put our phones on silent? And as you'll see, there's only one door out of this room, so if there's any issues, just run towards there as quickly as you can, and hopefully we won't leave anybody behind. Q&A is going to be at the end of the 2 talks, so if you have any questions, just store them up. We'll have a microphone going around, but we possibly won't need a microphone with the number of individuals here, but we'll deal with that at the end. And then afterwards we have wine, beer, and a few nibbles for anybody who wants to stick around and talk to the speakers or any of the committee members. So first up is James Burke to deal with professional negligence with a construction slant. James is a practicing Chancery and commercial barrister with a particular focus on construction law and professional negligence. He's regularly involved in large-scale and complex building disputes. He also represents professionals from the construction sphere and professional negligence proceedings, and he's been involved in a number of judicial review applications in respect of the adjudication process pursuant to the Construction Contracts Act. Currently involved in a number of enforcement applications, and he is also a member of the Construction Bar Association. So without further ado, I'll pass you over to James.
Thanks a lot. Thanks very much. Good evening. I suppose really I'd prefer if it was raining than sunny this evening, so we could have an excuse for being inside. My talk, obviously, as Noel said, is professional indemnity insurance negligence with a focus on construction. I'm going to look at the focus of what I'm going to talk about is more practical consideration of dealing with construction disputes. And the reason for that, I'll give you 2 examples, two kind of cases that I'm in at the moment. One is to do with a dispute in relation to a stadium, and that's a professional negligence action but it's against one party, but they're multidisciplinary. So that party is an architect. They carried out the engineering role, they carried out the project manager role. So it's multidisciplinary. So there are certain layers to it, and obviously with that comes more expert reports and that. So it becomes quite complex. Another case is in relation to a dispute in relation to a building that's close by, to do with heating system and valves and coils. I think Kennedy's are in that as well. There are a number of parties in that, but it's a third-party litigation. And that there are 5 third parties in it. So again, you had the plaintiff and the defendant, that matter has been settled, but then you have the defendant pursuing the third parties, 5 third parties. And again, that is quite complex, but more so because of the issues, but also because of the number of parties. And the reason I'm starting with that is simply because professional negligence in construction is the same as any other professional in that you're kept to the standard of your peers. It's the same kind of standard of your peers of a reasonable acting person. Why construction is slightly different is because it becomes more complex with the numbers of parties you have, and it's hard to get away from the parties unless you're focused on one specific individual. And that's because obviously if you think about it, we've got a building that has to be designed, that has to be planned out, and then you've got to get contractors, further engineers, mechanical civil engineers, and then you've got obviously architects, project managers, so there's a multiplicity of disciplines that are involved in it, and then on top of it you've got the contractor. So any issues that arise out of a building can become quite complicated because you have to look at all the professionals, if there's negligence there. They'll be pointing to, well, it's bad workmanship, so you have to look at that. Then after that, you've got to look at what happens with remediation, what damages, how much is it going to cost, and you've got to quantify those losses. So before you know it, you've layers and layers of parties, issues, and the courts still look at it from simple. First of all, you've got your negligence, but also first of all they look at the contract and scope of duty, and then whether it's consistent with the contract and the duty of care. So I'm taking a slightly different stance, and that's why I think it's important to consider all the issues when looking at professional negligence in construction. And what I want to look at is first of all, when you think of negligence in buildings and that, you need to look at the parties and who's responsible and the issues that arise. So like the Civil Liability Act is supposed to be our friend and is a friend and a foe in equal measure for parties. Obviously, it can be considered a cause of having so many parties. For example, Section 12 of the Civil Liability Act provides the 1% rule. Clearly, everyone knows that if you're 1% liable, you're liable for the entire 100% of the building, and that creates issues for plaintiffs that they want to include everyone in the proceedings, and therefore, you have a scattergun approach of including everyone and anyone as possible, and therefore they don't want to leave anyone out. The other kind of section that's relevant is Section 35 of the Act, which again, H, I, and J are the main factors or sections, and they deal with imposing liability on the plaintiff where there's a release or accord. So if the plaintiff settles with one party and then pursues the other, and the other defendants haven't been able to get any contribution for them, then the plaintiff will be affixed with that liability. I is if they've just left the party that's statute barred, again they're fixed with that that portion of liability. Then you've got, if you get judgment against one and you proceed separately against the others, you're fixed with that as well. So as was noted, and the constitutionality of all this was challenged in a case called Éireann Road Éireann and Ireland, decision of the Supreme Court in 1996. And what happened there was you had a train going along the tracks, and I think it was Sligo, and it hit cows, and then there were a number of individuals that were injured, and there was, I think, back then the damages were going to be about 4 million between all of them, and the court apportioned liability of 70% of the farmer and 30% of Éireann Road Éireann, but it turned out the farmer didn't have any money, and Éireann Road Éireann were very disgruntled about this being fixed with been fixed with a large proportion of the liability and picking up the tab. But what's important about this case was that the court looked at the Civil Liability Act and it said the three kind of points from the Civil Liability Act were that it said, subject to the rule that the plaintiff cannot recover more than the total amount of damage he has suffered. So obviously a plaintiff can't be unjustly enriched, but they're entitled to recover whatever damage they've suffered. Secondly, concurrent wrongdoers should be entitled to recover fair contributions from each other in respect to damages paid to the plaintiff. And again, that's important from a defendant's point of view, because you want to be able to recover if you pay out for a plaintiff, you want to be able to recover that money against other wrongdoers and be able to pursue them, and you shouldn't be shut out against them. And then all matters relating to the plaintiff's injury should, as far as possible, be litigated in one action. That's not always the case. You also have Section 17.2 of the Civil Liability Act, and that's important for if you settle with one defendant, or you settle with the plaintiff as a defendant, then you need to be careful of not shutting yourself out of being able to pursue other defendants. And a good example of that is the case of the Bernie Madoff, its defender and HSC. And just briefly on that case, why that's important is because in the Bernie Madoff case, everyone's obviously aware of it, of the Ponzi scheme. Defender were a fund, they invested in the Ponzi scheme, they lost, I think it's 540 million or some number like that. They settled with the bankruptcy trustee of the Madoff fund, and they got about 75% of that back. They then went and came to Ireland and pursued the other parties for the remaining 25%. This ended up in the High Court before Mr. Justice Toomey. Everyone was lined up for, I think it was listed for 6 months or so, for something like that. Mr. Justice Toomey came out and said, but you've got Section 17.2. I mean, you have gone and settled with the main wrongdoer, and therefore you're not entitled to pursue or HSBC. Paris, I think, was the company. So obviously everyone was stunned by this, and that's a bit unjust. Surely you should be entitled to pursue other defendants, as was the case here, and why should they be fixed to that liability? They went off to the Supreme Court, and the Supreme Court, while agreeing with the interpretation of 17.2 by Mr. Justice Toomey, held that in actual fact, what it says was that that's not a fair interpretation, and you can't interpret Section 17.2 to be solely that you're cutting out the more or the least culpable party, as opposed to just someone who's done what in that case was a criminal wrong. So what the Supreme Court said was it was nevertheless wrong to conclude that the only possible outcome of the application of Section 17 and 35 IH of the Act was an apportionment of liability of 100% against defender. So in essence, it would be unfair to deprive a plaintiff of an ability to recover losses because of one of the concurrent wrongdoers was more blameworthy. And that's important because that comes up a lot, is like when one of your co-defendants isn't playing ball, but you want to settle the case and reduce your exposure to costs as against for the insured party, that you can settle with a plaintiff and then pursue another culpable party after settling and dealing with an injured party. So that's a brief look at civil liability, which is important dealing with any kind of professional negligence claim, but also the reason you say it's by design or madness, why I'm linking it into professional negligence in construction cases. But in my experience, in construction cases, it's very hard to get out of cases once you're in them for your client. And you need to use the tools that are available to you, like the Civil Liability Act, to either settle and reduce your exposure to costs and pursue other parties, or else seek a contribution from your co-defendant, which is obviously a normal issue. An example of where the courts are very slow to extricate defendants is a case of it's Montrose and Cogent Project Cost Management Limited. It's a decision. It was an application by the 10th named defendant, Dean Roofing and Cladding, where they brought an application to strike out the case against the plaintiff. I think there was 12 defendants in total, but what happened in that case was that the Dean Roofing said, well, you've no case against me, and they raised a number of particulars, and strangely in this case, Dean Roofing, or the plaintiff, Montrose, came back and said, well, in actual fact, you don't have any liability for any of these issues, but when we get discovery, we're going to particularize that even further. There was one discrete issue that the defendant got an expert report to say, in actual fact, there's no liability for that either. The plaintiff didn't contest that issue, but in any event said, no, we're going to get, once we get discovery, we're hampered in dealing with the case, and once we get discovery, we're going to deal with, we're going to particularize our claim further. And Mr. Justice Simons refused to strike out the case because he said what he said was, in actual fact, once they get the discovery, he agreed with him. He said, well, not this case. Even though it's a very weak case, I'm not happy to strike it out. It has to be that it's bound to fail is the test. And therefore, in those circumstances, I'm refusing to strike it out. And why I use that as an example, because that is just demonstrative of a case where, for construction professionals, even where the plaintiff is accepting that that their case is very weak, and you've experts' reports backing you up, that in actual fact the courts are still hesitant to strike out a case against defendants, that they just want to keep them alive. The next case then, from the point of view of certificates, is a case by Egan, it's called Egan and the Governor and Company of the Bank of Ireland, 2024 IEHC 26, and decision of Mr. Justice Barr. In that case, what happened here was there's an architectural technician who provided a certificate to a plaintiff for a building that was that he said complied with retention permission. It turned out that the building was on two plots, and the building, the way it was reconstructed, bounded across the second folio, and therefore there was a breach of planning permission, and the plaintiff was obviously got into trouble over that and was in breach of the planning permission. But in any event, the architectural technician provided a certificate which stated that, or provided a certificate for it, but he said that in actual fact it didn't provide negligence. There was no negligence in the case, and he again brought an application to have the case struck out as against him. In that case, Mr. Justice Barr refused to strike out the case because the plaintiff had provided at the last minute an expert report to say, well, actually there was negligence, even though it didn't go to the core of the issue, and the courts refused to strike it out against the architect on the grounds that an expert report established that there was a basis for arguing that the fourth defendant acted negligently in providing the certificate. So the test is very high from extricating yourself from any kind of professional negligence construction cases. And also, I suppose courts are always slow to strike it out when there are numerous other parties, because they say, well, you're protected by other parties and you get a contribution from other parties in the case. Again, there's another case from a different angle, but again, it's architect certificate that was relied on. And that in that case is to do with performance bonds. And what happened is, it's called Gambira Limited Amtrust Europe, citation 2024 IEHC 188. In that case, the main construction company went into liquidation, or carried out a contract. They terminated the contract because they went into liquidation. The developer terminated. They had to get a new company called Gambira to finish the works. Once they finished the works, they went to pursue. There was obviously a shortfall in the money for the contract, and they went to sue on foot of the bond. And they went to sue on foot of summary judgment, because obviously with an architect's on a bond, it's usually a license to print money that you just press go. But this was a different kind of bond. It was what's called an unconditional bond. It wasn't a bond on demand. It was what's called a conditional bond, and therefore the test to satisfy the bond was slightly different. But one of the points that Gambira were seeking to rely on was the architect's certificate, which provided that in actual fact the money that the work was done and the money that was incurred was, I think, was 34 million. And that was an application for liberty to enter final judgment. But what's relevant about it is that the court refused to enforce judgment on one of the bases being that the certificate was not an actual fact, a certificate to say that the price or the cost of the works was an exact figure. In actual fact, the work was an estimated value of the complete works. So certificates obviously need to be read specifically. The language has to be clear and precise. And in that case, the court considered an adopted approach in a case called Token Construction and Charleston Estate, which is a decision of Lord Justice Roskill. And what he said was, it is in my judgment essential that while the architect is left free to adopt what form of expression he likes for the grant of a certificate, as the case may require, he must do so clearly so that the intent and substance of what he does is clear. The court should not be astute to criticise documents issued by an architect merely because he may not use the precise language which a lawyer might have selected in order to express a like determination. But whilst this amount of latitude is permissible, it cannot extend to the court's treating as due compliance with contractual requirements documents which, however liberally interpreted, do not plainly show that they were intended to comply with and fairly understood to comply with those contractual requirements. So effectively, the language of a certificate has to be clear and precise. It can't be ambiguous to be relied on. And that relates also to cases or to ordinary certificates provided for practical completion or interim certificates. The language has to be clear and precise. It can't be ambiguous. So they're kind of a look at the current cases that I could find at the moment on certificates. Generally, the professional negligence cases in the courts at the moment, you'll find a lot of applications to strike out, either for delay or else for no cause of action stated. You're more likely to get succeed in a case for no cause of action to succeed than you are for delay than no cause of action, because it's extremely hard, as you've seen in the Montrose case. The last thing then that I suppose to protect in dealing with construction cases, one of the most paramount important issues for defending cases are Calderbank letters. And obviously everyone knows here that Calderbanks again have to be specific in the language they use. Obviously must be headed without prejudice save as to cost. It has to have a specific offer, and that's probably the most one important thing in relation to Calderbanks, is that there must be a specific offer. It can't be ambiguous. What's being offered, obviously you have to offer the costs or whatever you assume to be the costs. They have to be reasonable costs to be tax and default agreement, and it has to be left open for a period of time, and therefore there has to be a specific date in the Calderbank in it. Calderbanks obviously weren't used all the time, but now they become more into play because of Section 169 of the Legal Services Regulation Act. And that provides that all efforts to settle cases must be taken into consideration, which would include Calderbanks. And Calderbanks are obviously easier because there's no time limit in relation to Calderbanks, and that's an important issue. In saying that, it's still hard, if you look at the cases, it's still hard to succeed with Calderbanks. And a good example of that, they're certainly very relevant for applying pressure. And one thing, everyone thinks of Calderbanks from the point of view of the plaintiff. They can also be used interdefendant, or obviously from the plaintiff to the plaintiff to the defendants as well, that they can send a Calderbank offer. I've used them interdefendant, and they can be very useful in that way. The main one obviously is defendant, flowing from the defendant to the plaintiff. An example of a case which is demonstrates the difficulty with which achieving a successful result in relation to Calderbanks is a case of O'Reilly and Neville. It's a decision of the Court of Appeal of Mr. Justice Morris Collins. And in that case, what happened was there was a defective building, a dwelling, I think it was a duplex building, and the parties agreed that there was an issue with the building, but they just couldn't come together with an agreement as to exactly what the how to resolve it, which seems to be a normal problem for construction cases, particularly is that the remediation of a problem, because construction costs are so high now, that the remediation of it can prove as contentious as actually identifying the issue. In this case anyway, despite the fact that they all agreed that something had to be done and their remediation work, the case ran for 12 days in the High Court. And at the end of it, the trial judge directed specific performance of the agreement, the building agreement, which he said, well, they're entitled to a new roof. And there was an offer from the defendant, the builder on it. Was it the builder? I think it was the builder. Sorry, it was the architect to provide remediation work in relation to the roof. There were also some other issues the court didn't offer or didn't find damages, but gave an order for cost for renting alternative accommodation. I just find. So what happened was that, so the defendants in their letter, the cost letter, they set out a procedure for identifying and remedying the defects through the use of an independent expert in a letter. And on foot of this, the trial judge agreed, and he said, right, I'm going to give the plaintiff got costs up to the date of the letter, and after that the defendant got the costs of the proceedings after the date of the letter, which obviously were significant in that case. The defendant appealed to the Court of Appeal, and the Court of Appeal overturned the decision. And the basis for overturning the decision was the fact that the offer to remedy the roof by an independent, if that was the case, what an independent expert had decided would be the appropriate solution was too much of a conditional offer, too contingent, and the language used wasn't sufficiently precise and specific. And in those circumstances, he overturned the decision to the High Court and gave costs to the plaintiff. So, and just to finish off with it, his quote was, so whereas the February, Mr. Justice Collins was, so whereas the February 2016 offer carried with it the possibility that the contractor would be directed to replace the roof, such an outcome was, as I've pointed out above, contingent and uncertain. In the face of that fundamental uncertainty, the plaintiffs proceeded and succeeded on the issue before the High Court. In my view, it cannot possibly be suggested that, in pursuing and obtaining a determination to the effect that the roof should be replaced, the plaintiffs did not win anything of value. On the contrary, it appears to me that that determination was and is much more valuable than any offer of a process that might or might not result in a determination to that effect. I.e., effectively, they were left with a kind of an unknown in the decision from the court or in that letter, so they couldn't accept it. While the title is looking at professional indemnity insurance, when you come to actual practice and dealing with professional indemnity insurance and negligence cases, it more comes down to how to manage construction cases and multi-party construction cases. And I suppose you obviously use the tools that you're given in relation to the Civil Liability Act. More important, obviously, one of the more important one is the Calder Bank letter. As the cases demonstrate, it's difficult to get out of cases by bringing applications. So you're let out, or else you have to protect yourself, put things in place to protect yourself, so that you're not exposed as a defendant to wide costs and apply pressure to the plaintiff in such cases. So, thank you very much.
Thank you very much, James. A lot of food for thought there. At least two of my ongoing cases, multiple defendants, failed Calder banks, and failed strikeout applications. It's all pretty much train wreck territory, and I know there's a few faces in the room that feel the same way I do. But anyway, away from professional negligence and construction-related cases, next up is Fred Gilligan to speak about data breach claims. Fred was called to the bar in 2005 and practices in Dublin and the Eastern Circuit. He specialises in insurance and commercial law. Fred represents and advises a diverse clientele of insurance companies, state bodies, large self-insured national and multinational organisations, and the State Claims Agency. That's quite a mouthful. Fred's been involved in a number of high-profile cases representing the state in the in-cell sanitation litigation and also the ongoing illegal adoption litigation. He has represented Johnson & Johnson in the Dupuy defective hip litigation, and I'm sure he's delighted to be able to say that he was involved in the recently concluded aviation cases, which apparently were never ending, but at least they have ended. So, Fred.
Thank you, everybody, and thanks to Kennedy's for having me and inviting us all here. I won't thank them for the free drink just yet. We'll see what the offering is like, but I'm sure it'll be lovely. I'm going to talk to you today about data breach claims, and in particular GDPR and the complexities surrounding it. It is an area that since its inception in around 2018 or so, it has become more and more popular. There are some plaintiff solicitors who are attempting to make a bit of a cottage industry out of the whole area, but they're not getting huge amounts of traction. But there's an undercurrent which just, I think from the insurance perspective and the defendant perspective in this type of litigation, just people need to be conscious of and need to be aware of it. I gave a paper to Foyle, I think it was online at the time in 2023, shortly after Judge O'Connor in the Circuit Court had given his decision in the Kaminsky and Ballymaguire Foods case. And that was a case involving, you may or may not remember it, it was a case involving an individual who recorded at work, and there was a data breach essentially of recognition of his face, and he suffered upset, distress and embarrassment. And he got €2,500 plus circuit court costs. And obviously the damages are not a huge issue there, but circuit court costs, as we're all very much aware, are an issue. So that kind of got the ball rolling for the plaintiffs in terms of where they're going to go with these claims. It set a very low bar of damages, but the Data Protection Act 2018 indicated or stated that all cases involving data breaches were to be issued in the circuit court. They weren't capable of being brought in the district court. That has since changed. That's important, and I'll come back to that in due course, but it's quite important to be aware of that. So that saw an influx of claims into the circuit court looking for low value money, 1,500, 2,500, but also crucially looking for circuit court costs. So the first real issue that in terms of dealing with those cases and in terms of fighting the cases was this idea that we will take a case. These cases are essentially, they're personal injury cases, and therefore they required the authorisation from PIAB. And at that stage, none of the plaintiffs were obtaining authorisation. They were simply coming in and going in on the damages for upset, distress and embarrassment type cases. So we saw Keane and the CSSO, which was a decision in the Circuit Court from Mr. Justice McAleese, just around the same time as Kaminsky, and he ruled in that case that the plaintiff did actually require an authorisation from PIAB. So that was appealed to the High Court, and it was heard by Mr. Justice Barry O'Donnell, who also heard the case of Dillon and the Irish Life Assurance PLC. What Barry O'Donnell held in the Dillon case and in Kaminsky was that both cases, that PIAB authorisation was required. And he looked at it, he gave a very detailed decision in respect of Dillon. It's worth a read. I'll give the paper to whoever afterwards, and you can look at it for the citations, etc. But he considered, the plaintiff had pleaded damages for distress, upset, anxiety, inconvenience, loss and damage. And he held that essentially, he looked at Clark and O'Gorman, which in the first instance, the case was brought by way of an equity civil bill in the Circuit Court. And the first issue was, can you recover damages for essentially distress, upset, personal injury type damages under an equitable civil bill? And in fairness, Clark and O'Gorman has settled that point. You can claim damages by way of a plenary summons statement of claim in, say, a constitutional challenge case, and you can look for damages for personal injuries within the context of that. But you do require an authorisation from PIAB if you're going down that route. Equally so, in the case of a equity civil bill which issues in these GDPR cases, because the plaintiffs always seek an injunction under section 117 of the Act, which is an injunction to stop my data being published or to control the data. it's a nothing in most cases, but it's there, and the plaintiffs are trying to use that to bring it into the circuit court all the time, and again that gets them the circuit court costs. But I'll come back to that point again. So Barry O'Donnell looked at Clark and O'Gorman, and he said, look, it's fine, you can bring your personal injuries claim in this by way of an equity civil bill or whatever way. That is, you're allowed to do that. But then he considered the issue of personal injuries, and in fact, while he was probably looking at personal injuries from a very, very technical point of view, he may have opened a slight floodgate, because what he ultimately found was that he goes through a lot of detail in his decision as to what is a personal injury. And he came to he looked essentially at this idea that stress, anxiety, upset, which are not recognisable psychiatric injuries within the meaning of general personal injury litigation, but they must impose they affect people mentally, and therefore they should be considered personal injuries. And he went right back in time, Murray and Budds in 2017, and in which the Supreme Court held that. And essentially what he was looking at was saying, he's expanded the definition of psychiatric injuries to include simple stress, upset, distress, which is somewhat worrying from the point of view of the insurance industry, because not only within the context of GDPR claims, but across the board, you could have a much wider scope for people bringing claims. Particularly so when you look at the personal injury guidelines. You fall, you break your leg. You used to get 20 grand in the circuit court and costs, happy days. You fall, you break your leg. You now only get 12 grand district court costs, unless, of course, you're deeply upset, you've got symptoms of PTSD, you've got a little bit of whatever else you're having yourself, and a psychiatric report from one of the recognised psychiatrists, and all of a sudden you get 17,500 circuit court costs. Nothing's changed. So the definition of psychiatric injury being expanded in the Dillon case is somewhat concerning in the context of personal injury litigation. That decision, it's worth noting, is under appeal to the Supreme Court, and my colleague who assists me in researching the paper, James Neal, sat in on the case, and he did say to me that a lot of the questions posed to the barristers on both sides were indicative of this query of, sorry, are you really saying stress, upset, embarrassment amounts to a recognisable psychiatric injury? So which way is the Supreme Court going to go in the O'Donnell decision? Is an authorisation required from PIAB, or rather the Injuries Resolution Board is now known, is an authorisation required or not? At the moment, yes, it is. It's a valid defence to say you're not authorised, but it may well not be the case in a couple of months' time. That case was heard in February of this year, and the decision, I suppose, will be expected over the summer. So why I talk about that is because these claims, GDPR claims, all bring about damages for non-material loss, and they essentially, non-material loss. Obviously, if your personal data is leaked, if your bank account is leaked, and you have €1 million taken out of your bank account, and you're only left with another 5 million, well, you have a very identifiable loss. I've lost €1 million. I bring my claim. I recover my claim for damages. It's a material loss. But this non-material loss under the GDPR is very vague, and it's not clear. And what Kaminsky with Judge O'Connor did do was it clarified. He said, look, the personal injury guidelines, we have them now in Ireland. Here's what you get for psych. Here's what you get for PTSD. And he set it out quite clearly. But there is now this grey area, which in a sense, I suspect Judge O'Donnell thought, I don't want floodgates. If you want to bring a personal injuries claim, you've got to get PIAB authorisation. But as we all know, as I said, non-material damage within the context of GDPR is now being extended to simple stress, upset, and embarrassment. So there's something just to be aware of and see where the dust settles on that case. I'm going to. So I probably should have told you what I'm going to talk about before I started talking. I'm going to touch on talked about the authorization issue. I want to talk about liability and defending the cases next, and then I'm going to talk about the levels of damages and where the trends are going in that regard, and then I'll finish up with data access requests and injunctions arising out of those requests, and just give you a nugget of a case I was involved in last week about that. But in liability, in terms of defending the cases, these cases have become quite difficult to defend, because most of the time what we see is a data breach, and data controllers have huge obligations on them under the GDPR and under the 2018 Act. So it's difficult. Once there's a data breach, you're kind of gone, unless you can show that for some reason it's outside the scope. And that is, in one such case, it was a Bulgarian case which went all the way to Europe. It's called VB, the Națională Agenția Pyrohodite. But essentially that defendant was an arm of the Bulgarian Ministry for Finance, and it was involved in the recovery and securing of public debts. Their database was the subject of a data breach by a cyber attack, which led to a data breach, and 6 million people in Bulgaria had their debts that they owed to the government published on the internet. And this became this rolled up, and they said, their argument was, look, hang on, we have a great system. We are so good on our data protection, and our cyber is brilliant, and our security is brilliant. This is outside of our control. And the European Court looked at that, and they said there was there's 4 issues that they had to look for. The first thing was, they said none of these plaintiffs ever asked. The plaintiffs mainly brought the case. I'm skipping ahead of myself. The plaintiffs mainly brought the case on the basis that we're seeking compensation because our data has been leaked. We don't know where it's gone to. We don't know what data has actually been leaked. We know we've been named on this list, but we don't know where it's going. Have you got our bank account details? We're all very fearful now of where our data is going to go, and it's causing us great stress and upset. And the first question the EU court asked was, or the first defence put forward rather to the EU court by the Bulgarian ministry was, look, none of these people have actually asked us what data was leaked. So without knowing what data was leaked, how can they be in fear? The next thing was, they said, and much more importantly, is they'd taken all necessary measures in advance to prevent the breach occurring. They also said there was no causal link between the breach and the non-material damage alleged by the plaintiffs. And they said, since we suffered a malicious cyber attack by personnel who were not our employees, we can't be held liable. So they were pushing the boat out on most of those defences. But in fact, their real and their strongest line of defence, and this was considered in a bit of detail by the ECJ, the European Court of Justice, was in the second one. Look, we've taken all steps necessary. And what the court held was, if you're going to run that defence and say, look, we've done everything we can do to prevent a cyber attack, to prevent our system being hacked, the ECJ said, well, you show us, you prove to us that your system was unhackable. And of course, how do you prove your system was unhackable when you've already been hacked? So it poses a difficulty. The court ultimately ruled in favour of the plaintiffs and said there was a data breach. They said your system wasn't as strong as you thought it was. Clearly it was hackable, and they sent it back to the Bulgarian courts for assessment of damages. They did just reiterate this fact that even an infringement, just the simple fact of an infringement of your data rights, is capable of giving rise to a claim for non-material damage, and that is something that they've certainly they've gone on about. They went on though in a second case in April of 2024 to tweak that ever so slightly. It's called GB v Juris GmbH, and in that case they said, look, hang on a second. They kind of went back on themselves and said, look, okay, a simple breach with no loss whatsoever, no loss, material or otherwise, is not capable. You don't get damages just because there's a breach. You've got to show some class of a loss. So that is quite important, and they've talked about Article 29 of the regulation, the GDPR, in terms of that, and that case gives guidance on damages and the situation and where damages arises. So that takes us nicely into damages and where the trends in damages are going in these cases in the Irish courts. So we had Kaminsky versus Ballymaguire Foods, which was the first case in this area where we really saw Judge O'Connor give a detailed decision, and he awarded Mr. Kaminsky $2,500 for stress, upset, embarrassment type non-material losses. We then, and crucially, there was no medical report in Kaminsky. It was pure stress, embarrassment, upset. So there was no medical report ever produced. Moving in then, we saw in November 23, Judge Jennifer O'Brien gave a decision in a case of MH and Tusla. Now, a lot of people said this award was quite high. It was $7,500. What happened here was the plaintiff's personal data that she had provided to Tusla was leaked. And it was quite serious. It involved data pertaining to disclosures she had made to Tusla regarding sexual abuse of her as a child. That data was leaked to her now deceased brother and also to other family members, and it caused a huge shift and a huge rift within her family, and it broke the family up in many respects. And in respect to that, she got $7,500. Strikes me that's quite a low award for what the actual damage was, but there may be a reason for that. A lot of the GDPR people are saying it's really high in the context of a GDPR claim. I would say yes, but it's very low in the context of a regular personal injury claim. The other case was Philip McCabe and the AA Ireland. Mr. McCabe, whose brother was his solicitor, interestingly enough, and that solicitor is one of the people who is certainly driving a lot of these GDPR cases. But Mr. McCabe was a mechanic with the AA, and he took sick leave. He hurt his back or something, and he had to go out on sick leave and take time off. And he was on a period of sick leave, and the day before he was due to come back to work, i.e. he was still on sick leave, he was spotted by 3 senior members of the AA's staff, and he was seen cutting down overhanging branches for his mother-in-law. So there's that classic stop. But one of the senior employees, or members of the management team who spotted him doing this, took out his phone and began to record him. And Mr. McCabe, obviously realising that he was in big trouble because he's on sick leave, I can't work, and yet here I am over cutting down branches and logs off trees, just got really angry and irate, and he took it up with the gents in the car. The following day he was called into work, brought to a disciplinary meeting, and immediately suspended on full pay pending an investigation into his sick leave, which ultimately ended up in his dismissal. The AA said, we never used the footage. We had 3 senior staff members in the car who witnessed this. Their credibility is beyond doubt. They can't be touched. And he said, it doesn't matter. Somebody who videoed me. I don't know who saw that. I don't know where you circulated it to. I don't know what happened to it. I've never been told it's deleted. It might appear on the internet in 3 years' time. I don't know what's going to happen. And Judge O'Brien, again, gave consideration to Article 82 of the GDPR, which deals with the right to compensation and liability. Ultimately, she found that the employee had recorded him, which he had, that the employee was acting in the scope of his employment, i.e. I don't know what he was doing, but he was scouting out this guy when he was supposed to be on sick leave, and as a result of being recorded without his consent and permission, and in the context of that data, that personal data, not being properly controlled, there was therefore a breach. So she looked at Article 82 and she summarised it reasonably well as follows: any person who has suffered a material or non-material damage as a result of an infringement of this regulation shall have the right to receive compensation from the controller or processor for the damage suffered. So that reinstates that right. Any controller involved in the processing shall be liable for damage caused by processing which infringed this regulation. A processor shall be liable for damage caused by processing only where it has not complied with its obligations of this regulation, specifically directed to processors, or where it has acted outside the contrary lawful instructions of the controller. Just pause for 1 second. A lot of people might be concerned that your private investigators who are out observing plaintiffs are in trouble here. They're not. They're gathering data. They have a good reason to gather the data. They're authorised. They're all licensed, authorised. They're regulated. They control their data, hopefully properly, and everything else. So it doesn't. This was a video recording ad hoc by an employee who really. Who had no business recording this chap. under a controller, and the third point then she made is a controller or processor shall be exempt from liability under paragraph 2 if it proves that it is in no way responsible for the event giving rise to the damage. And the AA argued that our employee, whoever was doing the recording, was not responsible, was not acting in the course of his employment, therefore they couldn't be held responsible. And she didn't like that argument. So she awarded Mr. McCabe €5,500 in damages, and we now see a significant volume of claims coming from that particular solicitor all across the board. So be aware. In terms of damages, really, there's been a number of cases since I last spoke to this forum about damages in GDPR cases. Again, they're in the paper, which I'll circulate for you all. But I think, look, it's important to note, as things stand, a breach in and of itself, simple breach, nothing arising, it's not enough. But anything beyond that, i.e. once the plaintiff says, I'm distressed, you have non-material damage. So that's important to note. The GDPR has, there's a couple of cases, but one is BL and Media Market Saturn. And that case just upholds the principle that damages for data breaches in GDPR cases, it's not a punitive exercise, it's a compensatory exercise. So you cannot get damages any more than just simple compensation. And it also confirms that they're not punitive as against the defendant, so it doesn't matter how good or how bad the defendant's record of maintaining data or otherwise is. Even if he's 100 previous data breaches, it doesn't matter. It simply only affects the one. They can't be compensated punitively. Only just compensation to put you back in the position, or for compensatory. That's principally been upheld. There's another case, and there's quite a few cases have gone around with this, which is the idea of the fear, the concept of fear. My data has gone out into the world. I don't know where it's going to end up. And the ECJ have held, and have repeatedly held, that yes, you can be compensated for a reasonable fear of your data being leaked, but you cannot be compensated for a hypothetical. Now, I'm sure we're all wonderful European law scholars, but it's very difficult to know what's a hypothetical fear of something about to happen and a reasonable fear of something that's about to happen. But we'll let the EU justices decide that, and I'll come back to you when they do. There's a couple of other cases there. Argentia and OL, which just confirms that non-material damage should be compensated for in the same way as a physical injury case, and they've referred everything back to the national laws in terms of what you're entitled to for damages and the quantum. So it remains the case that the personal injury guidelines, as they currently stand, are the guideline for damages in data protection or GDPR claims. So I mentioned earlier on that what we're seeing is a lot of plaintiffs bringing cases for damages in the circuit, or for damages for breach of GDPR in the circuit court, and then getting €1,500 and looking for a full set of circuit court costs. And that arises out of section 117, which is the injunction application. So the idea behind section 117 is that if there's an ongoing data breach, I can injunct you to stop my data being leaked, i.e. if my personal details are published on the internet or published in a book or something else, I bring an application under section 117 to injunct the defendant from publishing that and to remove the data. So what we see this idea that, you haven't told me that the data breach has stopped, so I'm issuing an equity civil bill, I'm issuing a motion for an injunction, I'm going into the circuit court and I'm looking for my reliefs. But there is no need for a plaintiff to issue an equitable civil bill, because the injunction is a statutory injunction. It's the same as section 160 of the Planning Act, which gives you the permission to go in and injunct someone who you think is breaching planning permission. It's the same thing. You go into the district court and do it. You can seek statutory injunction in the district court. So there is no need for cases in the circuit court. So when you get a GDPR claim in, your first port of call should be to say cost differential letter. There's no reason. Please remit this claim to the circuit court, to the district court. There's no reason for it to be in that. I had a case last week, Haley Kavanagh, Affidea Diagnostics Ireland Limited. I was acting for the defendant in the case. The plaintiff made a data access request. It was quite interesting, for her medical records and radiological imaging, which is Affidea, as you probably all know, is a MRIs and X-rays and all that. So they said, no problem. That's on your portal. It's all there. You can access it through that. And her solicitor, Mr. McCabe, issued an injunction seeking that but we were looking to injunct us, compelling us to provide all of our information. And we said, no, it's all there. It's on the app. Told him that from day one, but it ran on. It ran before we did legal submissions and all sorts for it. It ran before Judge O'Connor last Monday week, and he dismissed the plaintiff's application. And my clients benevolently said, look, they wouldn't seek their costs against her if she withdrew her proceedings. So, and that just remains to be seen, but I'm hopeful. But essentially what it does hold is that if someone makes a data access request, and we see them coming in all the time in the context of litigation, particularly personal injury litigation, where does that leave the defendant? Well, if you, and this comes from the EU law and from the recitals to the General Data Protection Regulation, and that is that if you have a portal where that person's data is securely stored, you can direct that person to the portal. So, and you see it a lot with Facebook, Instagram, and big social media accounts. If you write to Facebook and you say, I want all my personal data, please. What they will say to you is, okay, well, log into your account, click on that, click on this, and there's all your tags and mentions and @s or whatever it is, they're all there. And largely speaking, they probably are there. And that's a very efficient way of doing it, and that has been held by the ECJ, and in particular, it's in the legislation itself, in the GDPR, that you can allow that. So you don't have to write out, print out, send out copious pages and buckets of information. You can simply do it by providing an online portal, as Affidea did in that particular case. So where are we at? What we're seeing is we're certainly seeing an increase in claims for data breaches. They're being tacked onto other claims. We need to just watch what happens in Dublin and Irish Life, because where is it going to go? Where does it leave this idea of psychiatric injury when it's done? So that's important. The big thing, though, I think, big takeaway is to get these cases from the insurance point of view, not from the barrister's point of view, but to get them into the district court if you can. You'll save yourselves and your clients significant costs. So write your cost differential letter. Tell them you'd see no reason why it's a statutory injunction. It can't be brought in the district court. The level of damages is obviously appropriate in the district court too. I suspect what we will see, with thanks to the decisions of Jennifer O'Brien in those two cases, they've upped the awards, and I think there is a risk that awards could creep up, and certainly with the guidelines, obviously everyone probably is aware that the guidelines, personal injury guidelines, they're high on psychiatric damages. So if somebody can come in and show, well, as a result of that letter being leaked, I now have symptoms of PTSD and I've got this and I've got that, all of a sudden you're kind of creeping back up above 15,000 again. So that's where it's probably going to. So I hope that was of some help to you. Okay.
Thank you very much, Fred. We defended a case once where I think it was the plaintiff's medical notes were accidentally sent around to a number of co-workers, and I think the note said no serious medical issues, patient could exercise a little bit more and possibly drink a little less alcohol. And that was the basis of the claim, and I would suggest in Ireland very few individuals could actually pursue a valid claim on the basis of those notes. But anyway, maybe it was Mr. McCabe actually, although I don't recall him. But anyway, thank you very much both for presenting, and if anybody has any questions, my colleague I think has a microphone there, but feel free to ask any questions of our two speakers.
James, in a construction case where there is multiple defects and they're not all caused by the one act of negligence, does that create a different scenario when you're talking about concurrent wrongdoers?
When you say they're not all caused by the...
Well, you could have a roof that's leaking, you could have a floor that hasn't been laid properly or whatever. If someone has a defective building and there's issue proceedings about it, if there are multiple defects and not all of them can be all attributed.
They're not all the same. They're not all the same damage, effectively. Well, if the courts would approach that on the basis that it's still the one building, you're still incurring same damage. I haven't seen them kind of devise damage in that way so far. So I think if it's still part of the one building, it's still all kind of the same damage. They interpret same damage very broadly. So I think, like even in that defender case, they were trying to say that it's not the same damage. The loss, like for example, the loss the loss from the fund by Bernie Maddox and the loss from the fund by HSBC, because they were different. No, I suppose that was money and it was lost. But in a building, it's the same point. It's the loss is the loss to the person for their building. If it was a separate building, I'd say it's certainly something, but it's still a loss. Still the same damage, I would say. And the courts interpret it quite broadly. Okay.
James, thank you. In relation to Calder Bank letters, I haven't always seen them issued. And are there circumstances you think where people are maybe missing out by not issuing them? Has it just not become common enough practice? Are there ever unadvisable situations?
I think some of the reason, certainly trying to protect your position, they should be issued. It's trying to quantify the damage that the plaintiff is looking for, and obviously if you don't believe it's also setting out your stall as to what you value the case, even if you accept if you're stating that you've no liability. But it's being in a position to be able to quantify it, and sometimes in construction cases it is very hard to quantify exactly what the loss is. But I would think that people should be issuing call rights in any event.
They tend to come quite, by the time a defendant can properly value the plaintiff's claim, it's often too close to the trial to actually make any difference. Because the reality is, you get you say in the High Court, you exchange your schedule of reports, you get them so close to the trial, say, Jesus, this claim is for loss of earnings is actually huge. At that stage, briefs are out, notice of trial has been served, obviously, you've got a hearing date coming up in a matter of weeks probably. The costs have largely been incurred. So it's difficult to see what saving is. And as James points out, you're setting out your stall in terms of negotiations as to Calder banks and tenders are the starting point. So if you think the case is worth 100 grand and you Calder bank or tender 100 grand, the plaintiff is going to start at 100 grand in terms of any negotiations.
Question for both of you. In terms of striking out for statute of limitations, it frequently happens in relation to construction cases, but obviously it's lots of different cases. We frequently end up in a situation whereby it's quite clear that the proceedings have been issued well outside the statute of limitations, even with the whole damage manifesting and everything else. In one example, we have the insurer's report saying that there's serious damage in the building, and the proceedings were issued 6 years and 6 months after that. So as far as we're concerned, we have an automatic strikeout application. But the question is, with that type of scenario, where further do you think you would need to be to actually go in and defend one of those cases with a reasonable degree of success in respect of seeking to strike it out?
So
I mean, you can say 6 years and a day, and that's a good argument and everything else, but I don't get the sense that very many practitioners would actually incur all the costs of going in there. What type of level would you suggest in terms of either additional time or any other factors that you might think would lead to a successful application?
Like if you can show a strong defence, will assist it. If their case is weak, and time, then like the court. I can't think of the case, but there is a decision there where the court did refuse it, even though it was past it by a few months. I can't think of that case now, and they gave a reason for it. I don't know, it was an illness or something.
In the context of the personal injuries case, in the context of any case where evidence is important, obviously a big point in the statute of limitations case is the date of knowledge, and you see that, well, we didn't know, and I'll defer to James, and I know construction is quite niche area in terms of the statute, but I've certainly seen cases where I've brought preliminary applications in terms of the statute, and I've been refused. I had one just last year, in which the plaintiff had obtained authorization. She had gone to one set of solicitors. She'd obtained authorization against about 6 different defendants, including my defendant. She then issued against one of those defendants, who was, in fairness, the main point of contact, if you like. And that defendant joined another defendant as a third party, who ultimately became a co-defendant. And the second defendant, the new defendant, joined my clients as a third party. Now, at this stage, the statute was 4 years gone. And we said, well, hang on a second, you clearly knew on day one that we were somewhere in the frame because you got an authorization against us. You then changed solicitor and you only sued one defendant. And now you're saying, oh, we only knew when they made the application. That can't be true. And in the High Court, we lost the case. We lost the application. Judge Barr ruled against us. Can't actually remember the name of the case, but Judge Barr ruled against us, and we appealed to the Supreme Court. And the night before the hearing, appealed to the Court of Appeal. The night before the Court of Appeal hearing, we got an email from the Court of Appeal saying, in light of the recent decisions, O'Sullivan versus Ireland, and there was another one as well, I can't remember it, I'll get it for you. It said, is this case not better left to the trial judge where evidence can be heard? Might have been Smith, yeah. But we couldn't go on with the appeal, so we withdrew it. We agreed with the plaintiff that with the appeal, our appeal would essentially fall away, but we would vacate the order of Judge Barr as well, so that the matter on the statute could be tried. But the unfair part of that is that my clients are now put to the expense of a full defence in what is quite a technical case with multiple defendants, and we're going to have to defend it. So, to your point, I honestly think unless you're really clear on it, you're not going to get statute of limitations. There was one other case we did in the context of the slopping out claims, where we brought a statute point. That case, he was 12 years, he had been in prison and forced to slop out during his time in prison, 12 years before he issued his proceedings. We brought that case and we won it in the High Court, and the Supreme Court held in our favour as well on a preliminary point, because he tried to argue the Constitution was an indefinite statute, and the Supreme Court said, no, it's 6 years. You knew you were slopping out when you were slopping out, obviously. You don't have an impairment. There's no reason why you didn't issue the proceedings. You're now piggybacking on all these other cases. So we were successful there. But I think statute of limitations as preliminary points have become really hard to win, because the court says you need to hear evidence.
I think they're fact specific as well, as to who your plaintiff is and the kind of background and what kind of defence you're putting up. I think there's sympathy there for plaintiffs, and they'll try to do what they can. It's like that architect's certificates, on one hand they'll use it against you to keep you in a case, and then on the other hand they'll use it to keep the plaintiff in the case.
Bad news, Noel, sorry.
Other questions? Maybe James, sorry, just in relation to the Calder Bank, in French, you might be able to help with this too, but it is more construction related, where effectively you do have expert evidence backing it all up, backing up your claim. You would think that you could rely on your Calder Bank in those circumstances, Now the evidence has been adduced at mediation, so it is without prejudice. But a Calder Bank is without prejudice also.
Yeah.
So you think you might be something where you could go back to the bank and say, well, look, come here, we're exhausted here. We have the evidence to back it up. It's all there in the report. It's been agreed at mediation. The mediation, of course, failed. Unfortunately, the plaintiff didn't accept it. But therein afterwards, you still have something. And in those circumstances, have you seen where Calder banks have been accepted at that stage, where there is, I suppose, co-defendants, they might go on to the other defendants eventually?
It becomes more complicated with the co-defendants because you're obviously trying to work together, and then you need to divide the liability between parties, and that obviously becomes a sticking point for everyone.
Yeah.
They're certainly helpful from the point of view of applying pressure that even if they're not going to accept the Calder Bank, they may accept close to it.
Yeah.
So if they're not going to accept it, I still think they're beneficial from the point of view of applying pressure to get the person to thinking about, well, we're at risk here. But it has to be, as Fred was saying, if you start off with the case is worth, you set it at 100 grand, then you're losing any ability to settle that at anything lower than that, or it just inflates as well. So there is a balancing act between what you're offering and what the case is worth. But and quantifying it is then the problem, making it valid one. Because if you pitch it too low, it's not worth the paper it's written on as well. So you have to pitch it at a level.
In circumstances where it's based, where you have the expert evidence, so you have it all based, effectively, you've calculated out completely to the point you can say to the plaintiff, look, that's it, the expert evidence is there, it shows it. You can go to the co-defendant if you want to get a bit more, if you want to get the cherry on the cake, so to speak.
Absolutely, but the problem is that usually what happens is it's left to the morning in the court and they say, well, you give us an extra 20 or 30 grand. And it's a case of, well, there's an issue about liability. Do we take the chance for the sake of 20, 30 grand and we're exposed for another 100 grand or so, or do we not? And invariably, it's a financial decision. It's all great about, like we all know, principle is a lawyer's best friend, but at the end of the day, there's no point in, holding something back where you're stung for an extra 100 grand. It doesn't make financial sense. And that's the most important thing.
Last chance. Fred, I'll ask you another question there.
Pull her away.
It's just more, have you seen ever with GTBR claims where there is a claim for kind of defamation and, okay, say it's a case like, for example, the Credit Register Bureau is someone's details are incorrectly registered on that, and they make an application. They know they don't have a case because of qualified privilege and so forth, and then instead they move towards the data breach claim. Have you come across those?
Yes.
Those type of financial situations.
I have in one situation where it went back to a recording of a plaintiff, and then was leaked in a kind of a roundabout way. That was spun differently on the internet, and he brought a GDPR stroke defamation claim. He was the guy who was in a supermarket. He was a supermarket employee, and he went up to he was bringing, the Lidl and Aldi and all these places, they have these big trolleys outside the front with loads of plants on them. So they're quite heavy. So he decided not to bother using the lift, the service lift, to bring the trolley down to the car park with all the plants on it. And he decided he'd go down the escalator. And he went down the escalator, and it's quite funny if you watch it online. He went down the escalator and out the door into the car park on the back of the trolley, and someone of the security guards videoed it on the CCTV camera, or the CCTV screen up in the office, and he sent it round to all the lads in the shopping centre and said, look at this, look what your man's done, he's an awful idiot. So then it's got like billions of hits on the internet. So we settled that with him because we didn't think it would be a good idea to let that run before a court. It was and he sort of had an element of defamation that said, look, I've been portrayed in this manner because of the breach. So they do link up.
Can I just go back to Killian's about the damage and the same damage? If you have, say, a chimney stack and then damage is done to the foundations, and you've got one individual, that Dean roofing one is one. On the roof, there was a specific thing that the contractor had done, and the majority of the claim was to do with fire safety mechanisms. The problem is, first of all, obviously the court didn't leave the defendant out in that case. But the problem is, you can contribute just for that specific damage to the pot, but when it comes to the court, they don't divide it down into, well, there's 20 grand for that, the defect there, and they're not going to give, they're going to give a general damage, or else damages for, a kind of composite figure. We just don't break things down into specific units like that. It would just take too long. It would be counterproductive from the point of view of running cases. So while it is a divisible damage, and you can say it's not the same damage, the reality of the situation is, because of the way things are settled in that, there's just one pot. And that's, you can get out and make a contribution for that one thing. Like, certainly that's a valid reason for getting out. We'd nothing to do with all the rest of it. And there's your 50 grand or whatever. And in actual fact, in that case, another defendant said, this is what we're liable for, and they assessed it, and they got an expert to assess it and quantify the damage. And they made an offer to, and they said, we will pay that. And they still weren't let out. They were still dragged along. So, I mean, whether they offered a Calder Bank or not, I don't know, for the point of view that it's never going to be divided down into that kind of specific units.
Well, in a construction dispute, your main damage is special damages. Sorry, in the construction dispute, your main damages are special damages, and there's very little by way of general damages.
No, but it's still, sorry, that's clumsy wording, but I mean that they still just give a general figure for it. They'll itemize it in a sense, but it will be like, there's kind of a headline figure for it. Generally, they will break it down, but when you're settling that, it's always round figures, let's say. That's underpinned by the itemized, but there's give and take. That's the reality of it, in my experience. Getting out for it, for one specific thing is quite hard, unfortunately.
Thanks, James.
Can I ask a question of Francis on data breaches? If you have a situation where there's a data breach, you mentioned a case, I think, involving Bulgaria, and if you have a data breach arising from like a sophisticated cyber attack, do damages automatically then flow under the Data Protection Act, because it's outside your control, it's criminals, it's not necessarily negligence, but is there kind of a strict liability there for all the damage that flows? I
think that's the concern, this concept of strict liability. What the European Court of Justice said in that case was, look, the burden is on the defendant ultimately to show that their system was up to scratch and was. Now, it's very difficult because obviously the fact of the matter is you've been hacked, so your system was hackable. So how good was it? So that's going to be that's difficult to defend, but I presume that's something you're going to have to get technical experts in to say, look, this was the top of the range. We've never seen a hack like this before. We don't know who these guys are. We don't know what they're working with. It's unheard of. Maybe then the court will say, okay, well, you couldn't have done any more to prevent that. In fairness, we also, if you then consider then when do damages actually flow, and just because someone hacks your system, it doesn't mean and the data is a breach. It doesn't necessarily mean that someone has suffered any damage, even non-material. For argument, like if someone hacks into the Central Statistics Office and looks at all of our census information, and they figured out who's who, what are they going to do with that? What is my, I can say I'm stressed, but there has to be a little bit of of proof coming from me that A, my data was accessed as part of that breach, B, what data was accessed, and then what fear do I have, and is it this hypothetical fear versus a realistic fear? So I don't think damages they're very clear, damages do not flow just because there's a breach. They are clear on that point, but then they kind of go back and say, but sure, look, sure, everyone is going to be stressed and upset and worried and this, that, and the other. So it's difficult. They're difficult to counteract. But in like the HSE claims, do you remember there was a few cases came out of that. I don't think most of them didn't go very far because people couldn't prove what data was actually taken and where it was and what was going to happen with it.
Well, thank you very much to Fred and James for their thoughts and insights. Very, very interesting, and they will be here for a little while more. If you want to pop out here, grab a drink and pick their brains for a little while longer, hopefully. Thank you very much.
Thank you.